You will have 15 minutes, obviously, which argue your case, so there's no one arguing against you, so you're good to go. And again, we are being visually and audibly recorded, so please try to record the recording as much as possible.
Okay,
And we have read the brief, so we're ready to proceed anymore.
sure. This case, Attorney Giovanna Scalata-Bremke, I represent Mr. Gilbert, Ramone Gilbert. This case was originally filed as a felony with 2 misdemeanors, and that was in June 13th, 2017. The felony was intimidation of a witness. That felony was dismissed at the grand jury, and there was an indictment on just the 2 misdemeanor counts of aggravated menacing and telephone harassment. And that indictment was filed on August 15th of 2017. The case proceeded to trial in September 7th of 2017, and it was a bench trial in front of Judge Elwell in Lorain Municipal Court. He was convicted on the aggravated menacing, and the telephone harassment was dismissed. This case revolves around the ag menacing charge, and particularly the knowingly element of that statute. And the statute is 2903.21. The knowingly is defined in 2901.22b. The arguments is the sufficiency and manifest weight, but again, my focus is on the knowledge and whether the threats were a Facebook video of a rap song in which Mr. Gilbert talked about burning up houses and children and making threats about killing a baby mom was the quote. The video was posted to Mr. Gilbert's brother's Facebook. In the video, Mr. Gilbert's face was not shown, and he wasn't the one to post it, his brother had posted it. Miss Corbin, who was the complaining witness in this case, was not mentioned in the video, and she was blocked from both Mr. Gilbert and his brother's Facebook pages. Again, the trial court even mentioned, and I believe it's on page 41, trial court says he struggled with the fact of whether these threats were communicated to Ms. Corbin. And that goes to the knowledge, whether he knowingly caused her to believe that there would be serious physical harm. His face was not shown in the video. The transcript on page 18, Ms. Corbin testifies that she's blocked from both Mr. Ramone Gilbert's page and his brother's page. The way that she did eventually see the video is a friend of hers had called her and said, this video is on Facebook. They couldn't download the video, so what she did is she went to the friend's house, or they met up, and she took a video of the video through the friend's Facebook page, who had access to the brother's Facebook page.
So I haven't had a chance to look at the video yet, but I was assuming it was a video of him performing this rap song.
Correct. He's playing an instrument.
But you indicate you could not see his face?
No, it's not.
Is it covered, or?
Yeah, I believe it's just like neck down.
Huh.
I can't see where in the I could get you where there was some testimony to the fact that his face wasn't in the video. He wasn't. Again, she testifies quite a bit. Page transcript page 18 and 19.
Let me ask you a couple other questions.
Yeah.
Is he identified as the artist performing? I mean, because he did indicate that he performs rap music and he places it on Facebook so people can discover him, right?
Right.
So was there some identifying factor?
that,
Sort of
I can't.
nonsensical to
Right.
not identify yourself if your goal is to be recognized as a rap artist, and that was your means of trying to get notoriety.
Right, well, I can't say with certainty whether there was an identity or not. I don't know whether when the brother posted it, he said, this is my brother Ramone Gilbert. But I can go to the fact that he did testify that that the video wasn't done and it wasn't there, wasn't his intention for this to be posted. He didn't film it himself, so.
Was he aware that he was being filmed?
I don't know that there's testimony to that extent, that he was aware that it was being filmed. But I know that he wasn't aware that he wasn't even aware at the time of his arrest, and there was testimony to this, that it was ever posted. He wasn't aware that it was posted until after he was arrested.
But wasn't there testimony that he knew it would be, or that he would be posting it because that is the manner he
So
uses
the
to
quote,
become-
I pulled it up. It was, were you intending to wait until the song was finished before you posted it? He said yes.
So he must have been aware that it was being recorded. He intended at some point to finish mixing or whatever he was doing to it before he posted it, right?
You could say that. I mean, I think that, the final version could have had these statements taken out. The statements didn't specifically, I guess even if he was intending on posting it to Facebook, there's still the argument that she was blocked from his Facebook, she was blocked from the brother's Facebook, so his knowledge of whether that would get to her, the way it did get to her is pretty distant. So the element is that he had knowledge that she would take this as a serious threat. He wouldn't have the knowledge that it would be communicated to her. As it was, she saw this video through a friend and she had to video it from another phone to get that video because it was so distant that she was able to see this video.
So was there testimony that if they had shared friends on Facebook that it would be available to her, even though they were blocked?
Well, she didn't use her Facebook account to see the video. She used the friend's Facebook.
But isn't the issue whether or not he was aware his conduct would probably cause a certain result? That's the definition of knowing.
Right.
So I guess the question was, if you have shared friends on Facebook,
Right.
it's going to be available to her, but I don't know if there was testimony of that or not.
No, and like I said, it was pretty distant. It was through a friend who had called her up and said this is on Facebook, and she, even after it was on Facebook, she still didn't have access to it, other than looking at the friend's phone. So she, went on her Facebook, she doesn't have access to that. So his knowledge of whether that's conveyed to her, and there still is also the issue that he doesn't mention her name specifically. He says baby mom, and that I think, and she also testified again, transcript page 5, she testified that she used the word no strife between them. They didn't, they weren't, there would be no reason for her to believe that these threats were, intended towards her more than a artistic rendition of a rap song, which is, in music in general, there's all sorts of statements that aren't necessarily deemed threats to specific individuals. This, again, she testified that although they were blocked, they didn't have arguments going on. There wasn't something going on in their lives that would cause her to believe that this was about her, or that he was,
Well,
Didn't he testify, I'm sorry, that there was a pending custody case between him and Ms. Corbin?
there was, and again,
She
he,
was actually living with him, is that correct?
yes, and there was, again, he says there's a pending custody matter. Of course, I wouldn't, while this pending custody matter is going on, I wouldn't talk about burning up my own children. This wasn't intended towards, burning up my children. That would be stupid for me to say, I'm burning up my children. while this pending custody matter. There is quite a bit of talk to that extent. So again, he's not saying that these threats were made specifically to her, just in general as an artistic rendition of a song. And, you know, even if she took it as that they were threats to her, they weren't, you know, they weren't communicated to her, weren't intended. He had no knowledge that they would cause her to believe that they were intending for her to believe that she would have serious physical harm threatened to her.
So we're not being asked to address any First Amendment issue here, freedom of expression.
No. Just specifically whether they were, and that wasn't brought up at the trial, so. But just specifically whether these were communicated to her, and whether he would, not whether they were communicated, whether he would have knowledge that this would cause her to believe that there was that she would be in threat of serious physical harm to herself, to her kids, to her property. And again, you know, there's several things that go against that. His face wasn't in the video. He was blocked from she was blocked from his and his brother's Facebook. He just does not mention her name. He just refers to baby mom. He testified that it wasn't that he didn't intend for it to be posted when it was posted. She testified that there was no strife between them. He didn't know that it was posted until well after he was arrested. He didn't film the video himself. He didn't send her the video. He didn't, you know, text message or Facebook to her and say, hey, I thought you'd like this video. He didn't do anything like that. And she testified in it's page 19 that he had nothing to do with her seeing the video. And that's almost, I think the question was that exact question. Did he have anything to do with you seeing the video? And she says, no, he didn't. Any other questions?
How would you distinguish the case cited by the state involving the
The
Sandy
Noble
Hook?
case?
I think it was in Ray PT, if I remember correctly. The Sandy Hook incident that was posted on Facebook.
That I'm not familiar with. I know this court has, I had addressed the Noble case, which was just this district.
I think PT was out of the 12th district, which,
Okay,
not our district, but.
right. In the Noble case, it was an agriculture teacher who had said to there was an issue with the union, and the teacher had made comments about the principal or superintendent to other teachers and said, I think one of them was, I wish I could put arsenic in his ham or something in the school refrigerator. And there was over the course of time, he had said stuff to individual teachers, and those teachers went back to, I think it was the superintendent, and said, you know, yeah, these were threats. This is a little bit in that he would have been aware that those threats would get back because he was telling the teachers that they would tell the superintendent. In this case, it's different because, again, that whole issue surrounded around a union problem where there was a problem with the union and the teacher was involved with the union and the superintendent, and there was a feud. This case, there is no feud. The threats were general threats. In this other case, this Noble case, he had specifically said, I wish I could put arsenic in this superintendent's hand. In this case, he's just saying it's an artistic rendition in general terms about children. He says children, he says baby mom, he never specifically mentions anyone's name. And again, there's no feud going on. And also, in that case, there would be a reasonable certainty that these teachers would go back to the superintendent because of the close relationship, because of this feud going on with the union. There was a reasonable degree of certainty that those statements would get back.
Thank you.
Thank you.
Thank you for your presentation. The court will take the matter under advisement, issue a written decision which will be mailed to both sides.